Yeah, we're here to talk about de-stressing our life. I heard the news report this week about the anxiety curve or the stress curve for people, and around age 47, we're at the low point in our lives. I remember when I was 47 and had kids, high school, junior high, it was a rugged time. That's behind me now and life has gotten better, but it's like this bell curve. And there's a lot of stress having kids in school, and so this is talking about this morning about a way that we can de-stress our life with some pretty important things. We've been doing this with Kinkaid now for 4 years, and I've met with more than 100 people, friends of the institution. The point I want to make to start off is that every one of us is a precious original. We're all unique, and our estate plans are all unique. There's no cookie cutter approach that'll work. In financial planning, you have different kinds of approaches for people at different stages in their career, at different wealth levels. You can kind of pigeonhole folks into a model, if you will. That doesn't work in estate planning. It's all very personal. It's all a matter of what that individual or what that couple wants to accomplish. So that's been our approach here. I've been doing this work in estate planning for 27 years, and I found that this is what people really want. There's an outline that you either picked up on the way in or that you can get on the way out. I'm not going to cover every item in it because I want to leave time for questions, but I wanted to give those resources to you, and I'll call your attention to things that you really want to talk about. At any rate, we're all individuals, we're all precious in that sense, precious originals. What concerns us is the people that we have in our lives, our family primarily, the property that we own and control, and the plans we make for those people with that property. And we're also concerned, or need to be concerned, of how we should be seen through the eyes of the planners that work with us. Those are the 4 Ps: people, property, plans, and planners. If you can organize your life in that construct, you're going to need advice from somebody as a planner to help you out. You're going to want to take stock of what you have and what you want to acquire. You want to look at the plans you have for your kids, potentially grandkids down the road. What I find is that everybody wants to have a sense of personal freedom. We want to be in control of our own lives. But what does that really mean? It means the absence of stress. We've got our mind working around how our life is organized. We don't have any major concerns. We have anticipated problems and we've dealt with them. Along with that, we all have a responsibility for planning our estate. And it's interesting to me that just 2% of people over the age of 65 are financially independent, which means that about 98% of people over the age of 65 are going to rely on somebody else for at least part of their support, whether that's continuing to work, whether that's their relatives, the government, friends, whatever it may be. Women especially want financial security. Females have still a statistical life expectancy that's 7 years longer than their male counterparts at the same age. And so our wives are going to outlive us, guys. It's just a matter of fact. In fact, over the age of 65, widows outnumber widowers 3 to 1. So the odds get pretty slim when you get into your mid-60s that the guy's going to continue and the women are going to be around. In the generations currently, women may not have been in the workforce as long as men. They might not have saved as much in their own accounts for retirement as their husbands. And yet women are more decisive than men. They make 83% of the major financial decisions for the family, either personally or with their husband. The husband tends to make those only 17% of the time on their own. The era of the man running the family is long, long gone. There was a survey from 2001, and I keep it in my outline because it's still valid today. The 70% of women say that providing for their heirs is an important thing for them to do with their estate, and yet only 14% have actually done that. So there's a disconnect. And why is that? Because we don't want to talk about estate planning. Nobody wants to really come to me and talk about death and taxes. That's not high on our list of things to do. We have enough stress with other things that we're worried about. But we need to take responsibility for that. And in such way, we can get rid of that stress. Estate planning may seem pretty complicated. It's hopefully something that's way in the distant future. We feel like we're going to be around to manage that later on. And when we really have accumulated wealth, that's when we want to figure that out. When we really see how our kids have grown and matured in their places in life, that's when we want to take care of that. There are also a lot of emotional matters that fit into estate planning. And when you've got an unfamiliar subject, for most people, estate planning is a black box. We don't understand it. We hardly even understand how to approach it. And yet we don't go to a professional because it's going to cost money, it's going to take time. We feel like we might be susceptible to a sales pitch. If I go talk to that life insurance guy, he's going to try to get in my pocket. If I go to the lawyer, he's going to be charging me by every 6-minute increment, every 10th of an hour, there's going to be the meter running on our conversation. So this estate planning becomes an opportunity for you to take care of your own personal care in case you're incapacitated for some reason, accident or illness or something. You can apply your preferences and your wisdom, your experience, and your own dreams to your estate plan. You can bring that element very much forward in your estate plans. You provide for those that you love, and you provide for those who you feel like you have a responsibility toward. It might be parents, might be a brother or sister-in-law that needs some help. The goals that I hear from people is they want to make sure that they minimize any delays in the transfer from them to their kids. They want to avert conflict in the family. They don't want fighting and squabbling over me when I'm gone. I want to take care of these things and prearrange everything so that there's none of that squabbling. They also want to avoid needless expenses and unnecessary taxes. So that's the charge from most people. Tom, if you can get those things done, that's what I want to accomplish. Along the way, you're going to find a qualified advisor who's going to help you. Odds are it's not ever going to be enough to purchase an online will and make your own estate plan that way. The attorneys tell me that they kind of like it when somebody does that because their fees will be much higher undoing the problems that you've created by doing that online will. They're not joking. So you want to find an estate planning attorney. You want to find somebody who's expert in this field, who knows the ropes. Estates transfers in Texas are it's about the best state in the union for having probate. The lawyers have made it an extremely friendly process in contrast to other states where it is complicated. But there are other advisors that you may want to involve too. Financial planner, life insurance agent, trust officer, an accountant. You probably already have some of these folks in mind. You may need them to craft your estate plan, or at least to inform them about what you're doing with your estate plan, but the attorney is probably the prime person. If you have specific desires for a charity, and it's a significant gift, you'll want to talk to a representative of that charity as well to make sure that any restrictions that you have on how they're going to use that money comports with their ability to abide with that restriction. So if you want to have a specific fund to set up a scholarship, you'll want to talk to a Tom Moore to make sure that they can put that scholarship agreement together. If you say, I don't want to pave the parking lot, I don't want my money to go towards facilities, but I want it to go to people, they're the folks who can do that for you. And it's a good idea to put that outside of your estate plan in a gift agreement so that if your feelings change along the way, you can modify that without having to go back to an attorney and have an additional expense. No two estate plans are identical, as I mentioned. Each one is exactly to fit the needs of the couple or the individual that's setting up that plan. And any of those professionals that I've mentioned will be willing to sit down with you and discuss at no cost what you want to accomplish and refer you to the right people. So that's not a difficult thing to do except finding time to arrange it. And in the course of our work here in Houston, I know a number of different board-certified estate planning attorneys, and I'm happy to pass along names to you if that'll help. You can at least look at them online and see what they're like. There are a couple that they kind of have a friends and family discount for Kinkaid folks, and all of them are capable and understand how to help people of your age. A couple of important things: that there are only two ways that properties can be distributed when we pass away. It goes through two processes. One is probate, the other is non-probate. So if you have a will, what your will says about the assets that it controls will be transferred according to the terms of that will. But I'm quite sure that most of you have assets that will transfer outside of probate. You most likely have life insurance contracts where you've assigned a beneficiary. Maybe it's your spouse, maybe it's your kids. You have retirement plan assets where you've named a beneficiary. The spouse's beneficiary is a statutory requirement unless he or she waives that. So the surviving spouse is always going to get the retirement benefits from the deceased spouse. You may have titled assets jointly in your name. Common in Texas to have joint ownership with right of survivorship for a residence. By operation of the death of the first spouse, the second spouse, the surviving spouse, takes title to the residence. So all that transfer happens outside of probate. Those assets are not controlled by the will necessarily, unless you want your estate planning attorney to drag them into your estate for distribution. There are two types of beneficiaries too. You can name somebody to receive an income only, or you can name somebody to get a remainder or a lump sum after a period of time. In fact, those are the three most common ways or the three primary ways that people will make transfers. The income often is like, give the income from this amount to my surviving spouse for life, and then to the kids. So the income to the surviving spouse and then the remainder to my children. But the three ways that you can transfer assets when you pass away: you can give it as a lump sum, and that's the most common way we think of it. I'm dead, my estate is probated, and so transfer everything, as I said, equally to my three children, and do it that way, as a lump sum. But that doesn't work for everybody. We may have kids that are too young. Unless they've reached the age of majority, they can't own that property. It has to be in a minor's trust until they reach that age, or maybe even longer. Maybe you want to give them, instead of a lump sum, the second option is to give them an income for a period of time, to get them to finish school, to finish college, to get started in life. And then maybe you give them a lump sum, but it comes later, maybe at age 25, maybe at 30, so that they can buy a home, start a business. In fact, I've had planning clients who will ladder out their inheritances. Every 5 or 10 years, the kids get another chunk because they feel like they'll be that much more capable of receiving that money at that time. Others know that their kids aren't ready, or that they make them vulnerable to predators by giving them a chunk of money. Our son Paul is a twin. Our kids are all three of our kids are great, but Paul is an easy touch. If Kathleen and I gave him $100,000 next week because we'd passed away, I promise you it'd be gone in a month. All his buddies would come up to him. My car's in the shop. My business needs a shot in the arm. I want to get married and get a ring. He's got a generous heart. He would gladly give them the money because he has it, and they would never pay him back. So our thinking, and I'm sure it'll change at some point, but our thinking is, let's give him $10,000 a year for 10 years. If he blows the first batch, he may not blow the second and the third, and he'll wind up keeping at least some of that money, or it'll do him some good as opposed to his friends who we don't want to be part of our estate. There are 3 questions that you need to answer, and take some time to think about these, and they're in the outline on page 5. Do we have enough to live on for the rest of our lives together and for the surviving spouse? That's question number 1. Most of us are going to answer no, but as you go on in life and you accumulate more assets, you may be able to say, yes, we're good. The second one is, how much do we want to leave to our heirs? How much for each of those kids is the right amount? For some people, it's every last penny. Let's get it all to them. I've just been renting this money. I've accumulated it, and I want it to go for their benefit and the grandkids too. Others say, you know, that's fine up to a point. The first $1 million is enough, but I don't want to give them so much that they no longer have an incentive to work. I don't want to spoil them, or I don't want them to have it too early. So you might want to put a cap on it. It's entirely up to you. And after you've answered that question, the third one is, to the extent that there's any excess or overflow, what do we want to do with that money? That's the social capital question. That's the question of, it's either going to go to taxes or it's going to go to charity. Do you have a preference? Do you mind if some of your money goes to the government? Fine, go ahead. There's nothing wrong with that at all. But other people say, you know, I earned it here locally, I want to keep it here locally. There are things that mean a lot to me. Maybe it's the Kinkaid school, maybe it's your alma mater, maybe it's the hospital that helped your mom through her last illness. You can sometimes redirect tax dollars into charity dollars, just applying that social capital. And sometimes we can make that work. The process of planning an estate, basically you're asking yourself, what are my responsibilities? And they appear in the outline here. You find out what you're supposed to do for yourself. You identify what your responsibility is to your spouse if he or she survives you. How about your kids, their spouses, grandchildren that you may have that they've given you? Sometimes it's parents or siblings or other people close to you. You identify what you owe to other people. Maybe there's a payback thing in your mind that you want to address through your estate plan. And sometimes it makes sense to treat your heirs unequally. I remember working with a gentleman who had 3 children, 2 daughters, 1 son. The son was a senior vice president of a Fortune 200 company and was very well set. His daughters were not so. The one daughter was a social worker, and the other one had special needs. She couldn't manage money at all. He and his wife had always felt we should give it in equal thirds for them, and he said that doesn't even make sense. Our estate isn't that large. We need to take care of the girls because our son doesn't need it. He felt uncomfortable talking to his son about that. His son said, "Dad, it's your money. You do what you want. I would probably take that and give it to the girls anyway. So by all means, take care of them the way that you want." Sometimes treating them unequally is fair. Our parents, my parents, maybe yours, felt it's got to be equal. I don't want to create division in the family by treating somebody unequally. Well, sometimes that's exactly the direction to go. Be thinking too that as you are planning this estate, where it can go, there are only 3 destinations for it. We call it the 3 buckets. It can go the first bucket to your heirs. And most of us want the bulk or all of our money to go to our heirs. The second bucket is taxes. Uncle Sam is going to stand there and try to collect something along the way. It's just a fact of life. Death and taxes, 2 things you can't avoid. The third bucket is charity. You can sometimes redirect a tax dollar to charity. There is no 4th bucket unless you do a horrible job with an online will, and that's the money that's going to go to the lawyer to help resolve all the problems to fill your other 3 buckets. You get to decide how you want to fill those buckets. And that's what our job becomes as estate planners, making sure that you maximize the money to your kids, making sure that we allocate the right amount between taxes and charity, and that we do it in a streamlined way that you don't have unnecessary expenses and needless stress for you now or for your family later on. There are some problems that estate planning can address that simply don't resolve themselves like it says in the outline. Here's how you de-stress. With those 4 questions looming in your mind, you want to have a durable power of attorney. You want to have somebody who can step in for you if you're incapacitated temporarily or permanently, who can manage things for you. You want to have thought about an advanced medical directive so that whatever your preference is for you, if you're gravely ill or seriously messed up, that you can give instructions and you don't have to have another family member make that decision for you. If you have a preference, an advanced medical directive is exactly where you get to say, that's what I want. Yes, give me a feeding tube. Yes, do everything you can to keep me alive. I have confidence that I'll be okay. Or go ahead and pull the plug, I don't want it to be a drain on the family. There's no wrong answer there except not making that decision, in my opinion. You have a chance to appoint an executor. It might be your spouse, it might be somebody else. Sometimes the worst executor is the grieving spouse. It's the worst time in their life to have to manage all this stuff. Maybe it's better to have somebody else that's close to you, but not your spouse, take over those responsibilities. But you get to choose. And the probate judge is almost always going to accept your selection. And by the way, don't just pick one, pick an alternate. If you pick your sister because she lives close by and she's great, what if she moves away? Or what if she's going through chemotherapy at the time and isn't really able to serve? Have a backup in mind. Is there a question back here? Also to name a guardian. And a lot of estate planning for folks your age gets hung up on that. Who do we want as guardian for our children? If, God forbid, both of us died in a plane crash next week, who's going to watch after the kids? Here's your chance to think that through and have it on paper. Again, that choice, the judge is going to follow your guidance almost exclusively, as long as it's still in the best interest of those kids. The biggest item on this list is that you get to make decisions under the advice of professionals and thoughtfully. They're not happening randomly. They're not happening just because somebody makes them for you. You get to choose. You get to decide. I have a section in here on where to keep your documents, and there are 4 different sections there. You might want to look at that on page 11 so that you have files that your executor can find, your family can find. There are lots of mistakes that are made here. Wrong things kept in safety deposit boxes. Yes, the banks still have those, by the way, and that can create a problem sometimes. So, imagine that driving over here this morning, you died. But that you're given 20 minutes to look back over your plans and make any adjustments that needed to be made before you move on to that next life, before you are on the tractor beam to heaven or whatever your belief is. You've got 20 minutes to sort it out before you passed away. Were you ready? Were you ready if you passed away? Or is there something undone? Have you not got that guardianship in place, or is it out of date? Do you have a will? Have you thought about these things? My suggestion is take 20 minutes to get started on that and do it first chance you get. Maybe it's this weekend. Maybe it's tonight. Make your own decisions, follow your own responsibilities, and don't let somebody else do it because it's kind of unpleasant, kind of not what I want to talk about, not what I want to mess with. De-stress your life by making affirmative decisions instead of letting this kind of weigh you down over time. Estate planning is merely a matter of personal decisions that you make. It's no more than that. You get to choose, you get to decide, and then as you're protecting your financial interests, your advisor is going to make sure that it's done in a legally proper and binding way. All you're doing is telling him or her what you want to accomplish, and they're going to make it so to speak. Questions? Yes, ma'am.
How old does a sibling have to be before they can be a guardian of your younger child?
There's no hard and fast rule about the age of a sibling being the guardian for their younger kids. I would imagine the age of majority being 18 would be the threshold, but in the opinion of the judge, they may say this 18-year-old doesn't really have the ability to do that.
Right.
Mom and dad might not want that responsibility either on that 18-year-old who's just going to college or hasn't really had life experiences.
So she named someone that was 18 years old. A judge could have the power to overturn that.
Yes, a judge could say this 18-year-old isn't the right choice. Let's find somebody else until this 18-year-old has had some life experiences and has the maturity to really take care of those kids. We want her involved in their life. Mom and dad wanted the family to stay together, so let's do everything we can to help that, but let's not put the 18-year-old at risk or the younger kids at risk because she's not prepared to handle this job.
So who brings this to the attention of the judge?
The person
That the 18-year-old is not mature enough?
it'll go through the estate planning or the probate process. It'll come to light. Obviously, we've got minor children here, and how are we going to handle that? If you've addressed it in your estate plan, you've kind of already greased the skids. You've named a guardian. To my daughter, Susie, if she's reached the age of 23. If not, select another one until she gets to that age. You can affirmatively address that. If you don't, then you're leaving it up to a judge whom you don't know to make that decision. My opinion is better to take care of that in advance. That kind of stuff can happen. And we all have opinions about it too, you know? Yeah, I'd be okay. I trust my 18-year-old. He's really mature. He's sharp. No, might not be the best choice. I remember what I was like at 18. I wouldn't want that. Other questions? That was a good one. Yes?
So if you have a trust set up and your estate planning and everything is in that trust, does it still go to probate, or is probate somewhat of an, it was my understanding that probate is somewhat of a non-event?
You have two choices for this. If you have a revocable living trust in place as opposed to a will, and that's going to transfer everything by operation of trust, you do not need probate. It'll all happen because you've set up the trust. And there are a couple of benefits to that. One is you don't need the involvement of the probate court. Second one is it's done completely privately. Your probate records are accessed by the public, basically, if they want to. Not that people really do. But a revocable living trust allows you to move things quickly and efficiently with less interruption and less asking of permission for it. By the trust document itself, you're able to transfer assets, retitle them, move bank accounts, and so forth. My wife and I have exactly that because we fear with our luck, we won't just get killed in that crash. We'll be in comas for a long time. And we don't want to mess with our kids. So our daughter, who's the oldest one, will take over at that point. And for us, that just gives us peace of mind. That really works well in some jurisdictions where probate is unfriendly. California, New Jersey, Maryland, New York. But in Texas, probate is so friendly, it's almost as fast as having a revocable living trust. So here it's more about privacy or other reasons outside of that.
I was just going to add, I'm a state planner, that you mentioned the durable power of attorney, but we're finding that a lot of banks and financial institutions are giving a lot of, making life difficult for agents when they are trying to operate under the power of attorney. But if they're named as a successor trustee on your revocable management trust and your assets are in the trust, then it's much more seamless in that transition during your incapacity. So that's actually one of the primary reasons we're drafting more revocable trusts now, just for that incapacity planning element too.
And to jump off of that, as it relates to a healthcare power of attorney, those only go so far. And so it's become more common for estate planning attorneys to also draft a standby guardianship, not for our kids, but for us, so that if we need that kind of support and help, guardianship covers things that a healthcare power of attorney or a durable power of attorney can't handle. And so it fills in the gaps. And so that's become part of the ancillary documents that attorneys are drafting these days. and also a nice protection.
So that's outside of the medical power of attorney?
Correct.
Okay.
Usually in addition to. Other questions? What haven't I addressed that you came here to find out about? Well, then I would just say this. Think about what your best plan is. Wouldn't it be nice to sit down with a seasoned professional and help you answer that question?
I have another question.
Yeah, okay, I'm sorry.
I'm sorry, this may sound kind of ridiculous, but this is something that my husband and I are always like, okay, you know, estate planning in general. After after our child graduates, in 18 months, we're gonna sit down and do this. Okay, after summer, before, there's some landmarks. How much, so I think just the whole idea of it is just so vast, so large, and it's not necessarily that we fear dying or we don't want to talk about it, because we talk about it all the time. It's just such a huge undertaking.
You never get around to it.
Exactly. How much, just to give some kind of peace of mind, we think it's going to take like months of talking to somebody like you. I know it's a very general, but about how much time do you think it would take to just get a basic plan going with an advisor?
When people come to meet with me, the 100 or so here at Kinkaid, we start with about an hour-long meeting, 45 minutes to an hour, and we kind of cover the expectations, how they should approach this. Some people take that and run with it, and I don't see them again. Others say, no, I want you to guide me. So I come to campus once a month to meet with them, and most people are doing this 5 or 6 times, 5 or 6 meetings. Sometimes quicker, sometimes doing it less in person and more by phone. At the end of those meetings, they are ready to go. They take recommendations to their attorney, who then implements them, usually within 4 to 6 to 8 weeks, depending on how the workload of the attorney. Each meeting they have with me is about 45 minutes long on average. And we do it in those steps because that gives time in between to be thinking about what we're doing, to be preparing a net worth statement, which is about midway through the process. Our whole process focuses on values and objectives, values of that couple. And they actually prepare a mission statement, if you will, for their estate plan that drives everything we do, and hopefully their attorney and other advisors as well.
And are there a bunch of worksheets that you have to do between those meetings? And,
Yeah, we
there's a lot
kind of
work,
guide you
right?
through the process.
Yeah.
It's amazingly not complicated.
Okay.
It's straightforward. If you don't have to eat that elephant all at one sitting, if you can do it in little bits and pieces, that's my job to help guide people through this. And it works pretty well. It is not as daunting as it seems, because like I said, it's a black box.
Right.
And for most of it was, anything but that. I'd rather go to the dentist. Well, at the end of the process, they say they'd rather see me than their dentist, so I at least get up about that.
You get above a dentist.
My husband's a
Perhaps
dentist.
it's-
You got one in here today? I know. That's funny.
Not that there's anything wrong with it. Let me finish with this. There's a little essay I want to read. A Chicago attorney of mine, a friend of mine, estate planner, uses this at almost every presentation, and I've adopted it for me. It was written almost 100 years ago by an advertising executive by the name of Bruce Barton. He wrote this for the McCall's magazine. He's the guy who created the character Betty Crocker. He came up with the name General Electric for the company. He was a congressman in New York and ran for Senate and then was beaten by Franklin Delano Roosevelt. So he was in pretty high company. The books that he wrote, he actually outsold Ernest Hemingway and F. Scott Fitzgerald in his day. So here's his little essay. There are 2 seas in Palestine. One is fresh, and fish are in it. Splashes of green adorn its banks. Trees spread their branches over it and stretch out their thirsty roots to sip of its healing waters. The River Jordan makes this sea with sparkling water from the hills, so it laughs in the sunshine. and men build their houses near it, and birds their nests, and every kind of life is happier because it is there. The river Jordan flows out to another sea. Here there is no splash of fish, no fluttering leaf, no song of birds, no children's laughter. Travelers choose another route, unless on urgent business. The air hangs heavy above its water, and neither man nor beast nor fowl will drink. What makes this mighty difference in these neighbor seas? Not the river Jordan. It empties good water into both. Not the soil in which they lie, nor in the country round about. This is the difference. The Sea of Galilee receives, but does not keep the Jordan. For every drop that flows into it, another flows out. The giving and receiving go on in equal measure. The other sea is shrewder, hoarding its income jealously. It will not be tempted into any generous impulse. Every drop it gets, it keeps. The Sea of Galilee gives and lives. The other sea gives nothing. It is called dead. There are two kinds of people in this world. There are two seas in Palestine. Isn't that great? So be the one kind, not the other kind. Thinking about your family, thinking about your estate plan, take the time, no matter how daunting it might seem. Get with somebody who can help you and put this element of stress outside of your life.